Okay, hello and welcome to Health in Europe. My name is Dr. Mary Guy. Today I'm talking about a wider project I have ongoing at the moment of writing about solidarity in European healthcare, looking at a range of areas of law, EU law and policy. Today I'm thinking mostly about EU competition policy and the insights that gives into where solidarity can be located or relocated in European healthcare. So the focus is on relocation in the sense that perspectives on solidarity may be changing in view of the increasing access of the increasing expansion of private sector delivery of public health services at a member state level, for example, and how that fits with the existing EU law framework that's adopted by the courts and continues to be adopted even in recent judgments such as the Court of Justice's 2020 judgment in De Vera and the current pending appeal in Caso Regina as well. So just to start things off and how we think about solidarity in healthcare, there's sort of two aspects at play here. One is the sort of relationship between solidarity and competition, which is typically framed in opposing terms, as sort of solidarity being the antithesis to competition. And also we have the dimension of the definition of solidarity at the EU level and also at a member state level as well. So if we take our starting point as this sort of tension between solidarity and competition, a starting point might be, to illustrate this point, might be this quote from Prosser that we do not come to the market as equals. That said, with regard to the EU level, we see that solidarity takes on a status as a health value and also relating to sort of bioethical concepts. You see that from Frischhut and Werner-Felmayer, also from work by Barbara Pranczak, for instance. The linkage between the EU level and the national level becomes clearer when we see, or when we recall, that European healthcare systems tend to be based on solidarity and the idea of accessing healthcare based on clinical need, not the ability to pay. In other words, solidarity forms the ideational point upon which member health systems converge, as Hervey put it a while back. So, on the one hand, we have European healthcare systems being based on solidarity. On the other, we have increasing recourse to competition reforms and market reforms in one way or another. And that might suggest that the distinction between the two is perhaps less than first thought. It's been considered that competition and solidarity are essentially two sides of the same coin when it comes to healthcare system reform and modernisation, for example. And it also raises questions about how solidarity is interpreted in the particular context of competition. And that is to say that there can be two forms of solidarity. Firstly, relating to sort of economic type narratives of market failure, and secondly, relating to a sort of public spiritedness or public ethos from Berger in 2007. So this relates both to the wider non-applicability of competition law if solidarity is considered predominant, but also the use of solidarity within the services of general economic interest exception as well. So if we frame solidarity and competition as a sort of continuum, as a sort of spectrum, if you like, and transpose healthcare concerns onto this, what we're seeing is, on the one hand, public healthcare or public health insurance being based on solidarity, very much at the solidarity end of the spectrum, and then private healthcare or private health insurance is something where we would expect to see more sort of competition, although there may be a solidarity focus within this. And from this spectrum, we can then go on to disaggregate up to 4 categories of European healthcare. So this idea of 4 categories was something initially scoped in connection with English healthcare by myself and others, but it appears to have a wider reference and hopefully learning for other European healthcare systems. And that said, it's not intended to be definitive for all healthcare systems. It's simply a framing device for certain types of activity that feature in various healthcare systems, and it's a way of introducing the arguments that get advanced in competition and state aid cases. So it starts with category 1, with, if you like, the traditional separation of public and private healthcare, category 1 being public healthcare provision or public health insurance delivered by public bodies, essentially, very much located at the solidarity end of the spectrum. At the opposite end, with category 4, we're obviously at the competition end, with private health provision and private health insurance delivered by private companies. But in leading up to that, what we have is category 2, is representing the expansion of private sector delivery of public health services. And perhaps more contentiously, category 3, which sees public healthcare providers treating private patients. So we might see this, for instance, where questions of eligibility for public healthcare come into play, for example, in connection with residency or citizenship. So it may not be a big feature in many healthcare systems, but it does exist, and it's certainly advanced in the competition cases as indicating that there is more competition than solidarity. And as I mentioned, category 4 is the final sense of private healthcare provision or private health insurance provided by private providers. So the idea is these 4 categories offer a framework for really underscoring some points that get raised. And typically, for those parties, and it's typically private providers challenging decisions by public bodies or in connection with public healthcare delivery. So to indicate that and suggest that perhaps the solidarity basis for the healthcare system is being somewhat displaced by market reforms. And we see, for example, advanced arguments in connection with patient movement, for instance, between moving from the public healthcare sector into the private healthcare sector, or where there's been a notable degree of category 2 activity, that's to say an expansion of private sector delivery of public healthcare, then that may be accompanied by patient choice policies as well. So if that gives an indication of how we can think in more detail about the interaction or the spectrum between solidarity and competition, then what of the relationship between the EU and the member state levels? Well, this is a further consideration relating most obviously to healthcare system organisation and what's been called by Hensher and Sauter the subsidiarity clause of Article 168(7). So the emphasis here on healthcare rather than public health. And here we see union action being constrained by respecting member state responsibilities for defining health policy and organisation of health services and medical care. And also some definition of what those responsibilities at a national level are. The reference to allocation of resources might most clearly be linked to the idea of state aid. But the idea of how subsidiarity operates in the healthcare context is quite interesting. In a more general context, Professor Carlo Panara's recently written a paper on subsidiarity versus autonomy, which has particular reference here. When it's considered at face value, this might be taken to suggest that member states are free to engage with competition reforms to the extent that they wish to. However, it's been argued, I think persuasively by Prosser, that Article 168(7) doesn't necessarily confer this freedom. What it would seem to do instead is indicate that member states are free to make the choice to engage with competition reforms, but that choices and decisions have consequences, and a consequence of engaging with market reforms is that EU competition law may become applicable. And how that works when we're talking about EU competition policy, what we're talking about is the antitrust rules, and that is the Article 101 prohibition on anti-competitive agreements and Article 102 prohibition on abuse of dominance, as well as the state aid or the prohibition on state aid of Article 107. What these have in common, there's other discussions about how well antitrust and state aid fit together, whether they're conceptually different. I think that's an interesting discussion with regard to healthcare, but not for today. Is the starting point's the same? Applicability of either antitrust rules or state aid rules is the undertaking concept. So that's defined from the Höfner case of asking whether or not there's an economic activity. It's further defined as offering goods or services on a market, and we get that from Commission in Italy. So logically, the answer to the question of whether there's an economic activity is going to be yes or no. So a further distinction then emerges when we try and answer this question. And if we see no, obviously this is pointing towards the solidarity end of the spectrum. This seems to be the case for cases involving managing bodies or purchasing activities. So we have cases such as FENIN involving the Spanish national healthcare system, quite notably, where the solidarity basis was thought to be predominant, and the purchasing activity which led or which enabled healthcare provision on a solidarity basis was not seen as economic. We see a similar logic at play in De Vera, the idea of whether or not, if you like, in reverse, that whether or not there'd been enough competition to displace the solidarity basis that had been advanced by the General Court, but was rejected by the Court of Justice. So, and also in Casa Regina as well, we have the sense of the activities of managing bodies, so indicating more, looking more at the solidarity basis. And in these cases, there is more of a focus on the characteristics of the national healthcare system, which is considered to be at odds with the undertaking concept because this is thought to be functional. It's in and of itself, it doesn't consider classification at a national level of public or private bodies, for instance. And we see this more functional approach coming out with regard to healthcare providers, to point more in the direction that competition law does apply. So this distinction between the two has been conceptualized in various terms by Van der Honden, for instance. The case law relating to managing bodies is describes as I think a sort of concrete approach as opposed to the abstract approach taken to providers. And Gallo and Mariotti have talked about a classic functional approach to providers contrasting with an attenuated functional approach to cases such as FENIN, so relating to management bodies there. So in addition to this, we have the services of general economic interest exception. So this is sort of basically answering the economic activity question, but with a sort of yes, but. So we're recognizing that competition law applies, but we're also recognizing that certain activities can be classified as SGEI and therefore exempt. And where this is clearly referenced, or a distinction that's clearly made, is in the Ambulanz Glöckner case, where standard patient transport services were considered subject to competition rules, whereas emergency ambulance provision was not. We also see the distinction more recently in the Brussels hospitals case, where funding was made available, public funding was made available to a certain group of public hospitals in Brussels on the basis that they had additional obligations beyond other private providers of public healthcare services. So this particular group of hospitals had a particular role with regard to continuity of service provision. So that an overview is the mechanics, if you like, of EU competition policy and how it's played out in healthcare to date. So in overview, the cases that I'm looking at in the paper start with Poussey and Pistre, typically the earliest case that's referenced, quite an unusual case relative to some of the others, essentially asking whether or not EU competition law applied with regard to individuals taking out private insurance and not just paying for a social security scheme. So on in the connection with antitrust, also on the antitrust side, we have AOK Bundesverband, which involves activities by German sickness funds, and this was thought not to be subject to competition law, and I've already mentioned the FENIN case. On the state aid side, we seem to have sort of clusters of cases emerging on particular themes. So implementing risk equalisation schemes, for example, prior to the Dutch 2006 healthcare reforms, which instituted mandatory private health insurance. And a few years later, by Bupa, who were the largest private insurance provider in Ireland at the time. They've since exited the market, challenging the Irish risk equalisation scheme. I mentioned briefly the Brussels hospital case already with regard to state subsidies. We've also got the Casa Regina case, which is currently pending appeal before the Court of Justice. And we also have the SGEI packages by the Commission from 2005 and 2012, which have particularly emphasised hospital financing, although also include a wider category of health and long-term care now as well. And last but not least, the Devera case is an example of private delivery of state health insurance. So linking these with the 4 categories and how that plays out, we see a case like Pusey and Pistra, for example, draws arguably on categories 1 and 4. So the SGI packages relating to hospital financing, very much on the public side, so relating, I would say, predominantly to category 1, potentially also reference category 2 as well, particularly with regard to the Brussels hospital case. FENIN, also an example of categories 1 and possibly 2 as well, and then the later cases, the more recent cases rather, of Devera, indicating private provision of state health insurance, and Casa Regina challenged by private providers of public health, public hospital services. Also in Casa Regina, this is an example of where we're seeing category 3 activity being argued in favour of the application of competition law, that the public hospitals were also treating some patients privately. And last but not least, under category 4, we have AG de Air, referencing a supplementary insurance scheme. So although seemingly suggesting private activity, nevertheless, what was examined in that case was the degree of state intervention and solidarity aspects as well. So that hopefully gives a better idea of how the 4 categories can operate. And all this background is really by way of setting the scene, if you like, for certain discussions. So what emerges from this case law and from the commentary is 4 inconsistencies which are quite difficult to reconcile. So starting with, I already mentioned the distinction that gets drawn between purchasing and providing with the undertaking concept, and that creating an additional inconsistency potentially between taxation-funded healthcare systems and insurance-based systems. There's also been discussion of, in some ways, aligning healthcare with perhaps more standard markets. It's an argument I have more sympathy with than I used to, but I think there's enough of a focus within healthcare systems and the diversity of healthcare systems to make that a sort of comparison on its own terms. Issues ongoing include scope for divergence between EU and national levels, both in terms of the extent of subsidiarity, or what is meant by the subsidiarity clause of Article 168.7 and its predecessor, Article 152.5, but also in terms of defining solidarity as well. It was noted in Pusey and Pistra, solidarity was being referenced not just in opposition to competition, but also very much national solidarity. So this was something for the member states to determine. Subsequent references tend not to include national so much, but there still seemed to be some kind of explanation there. And so in the paper, in the next section, I do think about how solidarity is being understood at a national level. And a further problem, or potential problem rather, is the different interpretations of solidarity and by extension competition at the EU level. So where we see these cases, for the first instance, they're being determined by DG Comp in the Commission. DG Santé has also conducted research into competition between healthcare providers and given quite a precise definition of solidarity as being 70% publicly financed. Certainly in the cases, we don't necessarily get to that level of granularity, just this more general sense of, is there a solidarity basis? So, and then within the cases, the Commission and the Court of Justice generally are referencing the previous case law, as you might expect, and the General Court and the Advocate General opinions seem to be where perhaps more creative or more adventurous interpretations are being made. So, for example, in De Vera, the suggestion that some competition in the system might be enough to displace the solidarity basis, as I say, was ultimately rejected, but it was being advanced in a different sort of interpretation by the General Court back in 2018. But the 2020 Court of Justice finding seemed to realign the older case law there. So thinking briefly about the national focus for solidarity, we seem to get different types or different interpretations of solidarities coming about. So solidarity is emphasis on the plural, perhaps. So with regard to the Dutch risk equalisation scheme, we see references to this ensuring dual solidarity. And that is between policyholders of differing health statuses on the one hand, and between different incomes by means of a cap on healthcare costs on the other. A different approach, again, was taken by the Better Care case, or in the Better Care case, by the UK Competition Appeals Tribunal. So this involved a private provider of care homes challenging activity by the public National Health Service Trust in Northern Ireland. And this juxtaposed the idea of internal and external solidarity and suggested that you couldn't move from internal solidarity and external solidarity. So what the UK Competition Appeals Tribunal was doing in that case was suggesting that internal solidarity was seen in cases such as Poussé and Pistre, where there was a social security scheme, for instance, and internal solidarity with regard to the members of that scheme, but suggesting that where you had private providers of essentially NHS services, this was something different. This wasn't like that sort of Poussé and Pistre logic. It was, you couldn't transpose this internal solidarity found in the European cases to this external type of behaviour, suggesting that solidarity might be owed, in a sense, between the taxpayers and the residents of care homes, but this was separate to the private care home providers. I've tentatively referred to this as a prototype reverse FENIN logic. FENIN and Better Care were pretty much contemporaneous, and what happened with the Better Care finding was that competition law was thought to apply, and then the case was remitted back to the then Competition Authority, the Office of Fair Trading, and by that point, so roughly around 2004, the first FENIN judgment had been handed down, and so the UK Competition Authority was then obliged to align itself more with this, and even now the guidance is still dates from 2011, so we're still very much in line. With regard to public services, the tone has been set by the EU level case law. How that changes remains to be seen. What we also see at a national level is what I've called a core of solidarity. And we see this coming out where there's been explicit attempts to institute competition reforms in healthcare. My monograph a few years ago looked at or compared and contrasted the Dutch and the English competition reforms in healthcare. So on the Dutch side, we see competition reforms being built around the core of solidarity, that is to say the risk equalisation scheme, but also Article 122 of the Zorgverzekeringswet, the Dutch Health Insurance Act 2006, which essentially clarified that Dutch competition law would apply to the private health insurers. There's been some question about this following the 2004 AOK Bundesverband judgment about German sickness funds. But it was clarified, in essence, even if EU competition law may not apply, Dutch competition law would. In England, a different approach was taken and competition was essentially put into the core solidarity. It was put into the NHS. Reforms have been ongoing since the late 1980s, but formalised by legislation in 2012. So this might be described as an example of what South has called competitive provision of SGEI. And controversy surrounding this 2012 legislation, the Health and Social Care Act 2012, actually attempted to engage with the SGEI mechanism. A Labour MP, Clive Efford, introduced a bill to essentially repeal the 2012 Act reforms and classify the NHS as being made up of SGEI. Sadly, the debates on this didn't go very far, and they were curtailed by one, but in particular by one Jacob Rees-Mogg MP, who, if that name sounds familiar, he's gained notoriety in the meantime as a prominent Brexiteer. And his argument was essentially linking solidarity, not engaging with it in terms of EU law, but suggesting it was a sort of Russian socialist invention, and it, as far as he saw, had no place in English healthcare. So that's just to give an indication of how questions of solidarity may end up being debated within at a national level. What we also see with solidarity is there's been a case in the Netherlands involving SGEI and the determination of SGEI at a national level. So I forgot to mention before, there's an additional dynamic of the EU member state interaction is not only Article 168.7, but also the fact that SGEI are determined at a national level, essentially. So Gendia is a Belgian company who challenged a subsidy being made by the Dutch Ministry of Health, Wellbeing and Sport with regard to subsidising a certain type of prenatal screening tests. And it was considered that these could legitimately be classed as SGEI. So to conclude then, the aim of this work, by focusing on solidarity, is an attempt to help move what I think risk becoming increasingly circular discussions of when an activity is or is not economic. So by giving that sort of refocusing, we can start to change, not necessarily change the discussion, but we can maybe start to advance it in different ways. The idea of having 4 categories of European healthcare, or up to 4 categories, gives a sort of useful framing device where we can see where competition and solidarity are both in operation, but also maybe in tension with one another. One thing I'm hoping this work will do is, by juxtaposing EU and national experiences of defining solidarity, perhaps also comparing and contrasting antitrust and state aid, will help to relocate solidarity in European healthcare. Where are the sort of fault lines? Where are the sort of distinctions in interpretation coming out? Is it at EU level with regard to a national healthcare system, or is it coming from the member states themselves? But of course, what's motivating this really is this changing interaction of public and private healthcare, and this is happening against a backdrop of what seems to be quite a static approach by the EU courts. Obviously, logically, it's going to be continuation of existing case law, but one thing this seems to suggest is that perhaps this isn't just about competition, it's actually also about constitutionalism as well. So how the EU member state competence might evolve then takes on a greater significance, and it might be more fundamental to this discussion than first thought. So something to bear in mind, particularly in view of suggestions, proposals even from the Conference on the Future of Europe to rebalance health as a shared competence. Obviously, the political will necessary to do that, it would be quite substantial. But this is one thing that COVID has sort of enabled as scope to start to have some of these discussions again. Okay, thank you very much.